Good morning, everyone. Thank you for joining us. We're just going to wait 1 minute to allow more people to join, and then we'll get started. Okay, I think we can get started. So again, good morning, everyone. My name is Michelle Hoover, and I'm one of the communications advisors at RPRA. And thank you for joining us this morning for our webinar on Blue Box and RPRA's approach to compliance. This session will help producers of Blue Box materials understand their obligations under Ontario's Blue Box regulation and RPRA's approach to compliance, as well as answer your questions. Next slide, please. So we'll be answering questions at the end of the presentation. To ask a question, click on the Q&A tab at the bottom of your screen, type in your question or comment and click send. Feel free to ask questions throughout the webinar, but again, we'll be answering them at the end. There's also an upvote feature where you can pardon me, another person's question, and this will move the question up the queue and prompt us to answer it faster. If we can't get to your question during the webinar, or if it's very specific to you, please reach out to our compliance team at registry@rpra.ca, and they'll be happy to help you. We have also enabled the closed captions features that transcribe speech to text on your screen. And we are also recording today's webinar, and the recording and the presentation will be posted to our website shortly after. So on that note, I will hand it over to Mary, RPRA's registrar, to begin today's presentation.
Perfect. Thank you very much, Michelle. So thank you for joining us today on this topic. The items that we're going to go through, as Michelle said at the beginning and the outset there, are our risk-based approach to compliance. So what that is. So what is a risk-based approach to compliance? Why does RPRA use it? And how does that apply when we're looking at all of the regulations? We're going to go through a summary of all of our compliance tools available to us, what they are, how we use them, what the process is. And then near the end, we're going to very quickly review Blue Box obligations so everyone understands those at a very high level. And then we're going to apply what we've learned, so the risk-based approach to compliance and how we use our compliance tools very specifically to some free rider ideas so that folks can understand how the approach works and when they hear and see and from RPRA. Next slide. So, as I said, the first step is just reviewing our risk-based approach. So the way that this works, and this is a common approach that's adapted by every single Ontario regulator. And so this isn't unique to RPRA. We take an approach where we say, let's start with how are we defining risk? And we define the risk as the likelihood of an obligated party failing to meet their responsibility, plus the consequence on the system outcomes. Now, I want to pause on the word system outcomes here. A common belief is that compliance is the outcome. Compliance is not the outcome. What is the outcome are the policy objectives of the ministry. And they set that with the entire framework. So it's not that compliance is the outcome, it's the policy objectives that are the outcome. That's what we mean when we say system outcomes. Next slide. So what does that look like? It translates into a fairly simple 9-box risk matrix, where RPRA takes every single contravention under every single one of our regulations and maps it to this. We've done that exercise. We're also evolving this as time goes on and our maturity grows. to have even more robustness to it. So it can include multiple dimensions, like, you might see something like tonnage of a processor being included, or tonnage of a producer being included. And we map that out so that the team knows, where are we putting our focus? What is the priority? So contraventions, and again, adding different dimensions. So a contravention that might hit low on the impact and likelihood, or might hit even medium, might not be an area where we're putting our resources to at this point. We're really focusing on those 3 boxes right now. And again, this is a common approach. I believe all regulators in Ontario utilize. They all have different versions of this risk matrix that they use. Some of them look like circles, triangles, all different types of shapes, but they all utilize a risk-based approach, because, next slide, it's the one that's the most effective and efficient, right? RPRA has limited resources. We want to focus on the policy objectives. It's consistent with our values that we have here. We can't if we were to try to get 100% compliance in every single one of our regulations with every single party, we would have to have amount of staff and budget that would just be counterintuitive to the outcomes. No law has 100% compliance for this reason. Everything is about a risk-based approach. Where are we focusing our resources? Where are we going first? What makes sense for us to proactively look into? It's why it's foundational to how regulators work, and it's foundational to RPRA's approach. So I'm hoping this can help folks understand, okay, there are reasons where we focus our resources and when. And it's all about that particular approach. You can also use this to think through what RPRA's response to potential non-compliance could be. So you could say, okay, what is the likelihood of something happening? What is the impact on the system? What would RPRA's potential response to non-compliance be? Is it going to be, and we're going to talk about some of the compliance tools right after this, would RPRA utilize resources to do prosecution and administrative penalties on something that's ranking on our risk matrix that's in the low box there, the bottom left-hand corner, versus the top right-hand corner? So, and again, keeping in mind tonnage is key. That's one of the dimensions of our risk matrix, to say, when we're looking at the impact on the system, tonnage is really important. So let's talk a little bit about what our tools are. Next slide. So we have 6 different compliance tools, and we do approach, I'm going to go through each of them with you. We approach it using a progressive approach to compliance. So what that means is we want to start with the proactive education and awareness, and we're wanting to end with prosecution. The vast majority of companies want to comply and will comply if they understand how and why. That is where the vast majority of our resources are going to go, is into that first tool. That said, not everyone does. And we know that, and the government knows that, and that's why we have all the other tools that we have. But what we want to do from an effective and efficient approach of our risk matrix is to put our resources in number 1. That is the more cost-efficient method compared to a prosecution, compared to administrative penalty orders, or even compliance orders. And as we go through what each of these is, I think you're going to see how issuing an administrative penalty order is not issuing a parking ticket. The process it goes through is quite robust, as it should be. And so it takes a legal department, it takes a fair amount of time, effort of everyone at RPRA. So you want us using those tools on the top right hand of the quadrant. And one thing I'll say before we dive into the tools too, while we have a progressive approach, nothing says that we have to follow this in steps. Yes, it's most effective and efficient to always start with 1. RPRA would never not start with 1. proactive education and awareness and removing barriers to comply, making sure people understand why, answering their questions. Yes, it takes time, but less time and less resources than some of the ones near the bottom there for sure. But that doesn't mean that when proactive education and awareness doesn't work, that we can't immediately jump to an administrative penalty. We can. The facts of the case matter, and that's where you want to look at that matrix, that risk matrix. It can begin to predict what to expect from us, consistency from our approach because of that risk matrix. Once you fully grasp and understand it, and I want to do that with everyone today. Once you've got that, you can see the consistency to the approach that RPRA takes in the enforcement of all of our regulations. Let's go through some of these though. So next slide. We've talked about proactive. Next slide there as well. We're going to talk about these three first, because these are the three that tend to be the main focus of our work. Next slide. So proactive education and awareness. Really what we're talking here is a concept we use. It's a bit of an inside concept, but communicating for compliance. It's commonly, again, it's not a RPRA term. This is supported by the government across all regulators. The idea is that you're doing proactive education and awareness, explaining the why, explaining how, removing the barriers. It does take time. But going back to the principle, the vast majority of companies want to comply. They need to understand why, they need to understand how, but they want to comply, and we're taking them through that journey. A lot of our regulations came out very quickly. The industries have worked quite a bit to understand them. Producers, recyclers have worked to understand these regulations, and RPRA's done what we can to unravel them, to help them understand the why and the how. But this is where the vast majority of our work is. Next slide. Then we have something inspections. So like any other regulator that you may be familiar with, RPRA inspectors have a fair amount of power to compel information, to ensure parties are actually complying. And it's very important that companies in Ontario, well, in Canada and anywhere that they're an obligated producer, understand that failure to respond or failure to do something an inspector at RPRA has told you is actually an offense. So you have to take it quite seriously when you're interacting with RPRA, and this is a big change for producers in the EPR framework. I'm confident that many producers are quite used to dealing with Canadian Revenue Agency or the Ministry of Labor, and that they understand that relationship. RPRA is now the regulator, much like any other regulator, with those same powers, but in the EPR field. So it's taken some time, but producers are beginning to understand this, that we are a regulator, and much like the way you would respond to CRA and do what CRA says within the deadlines CRA is telling you, you need to do the same thing with RPRA and RPRA inspectors. If you don't, there are real consequences for your company for those decisions. Next slide. Another one that we use is very much so a communicating for compliance technique. What these are registrar statements. So I frequently will issue out statements to the public talking about particular issues and where the focus might be. They're notices of compliance requirements, or compliance notice itself. These are not compliance orders, right? What these are communication tools to try to help companies understand the importance and the urgency around some of these obligations and the consequences that they may face, their company could face. And now let's talk about what those look like. Next slide. So we have compliance orders, administrative penalty orders, and we have prosecutorial powers. We're going to focus on compliance orders and on administrative penalties today, so folks can really understand what this process looks like. And when we get to the end, I do have an announcement, which I think folks will appreciate why I'm spending some time on the process here when they hear that. So compliance orders. If you receive a compliance order, this is different than a compliance notice or different than a compliance requirement, different than a letter from an inspector saying, I require this by this date. All of those are legally enforceable, but a compliance order is different. What happens is an inspector or the deputy registrar or the registrar at RPRA finds not evidence of non-compliance. We going back to our progressive approach, we always want to communicate. We're going to phone, we're going to have email communications. We're going to try to help the person understand what they need to do to remedy the contravention that's being committed. A lot of our contraventions under the EPR regulations are contraventions that you can remedy even after you've committed the contravention. So for instance, failure to report to RPRA, you can by the deadline, you can remedy that contravention by reporting. So there's things that can happen that we can tell folks to do to remedy a particular contravention. Next slide. But these are legal instruments. They're legal documentation. They involve lawyers. They're reviewed before issued by management. When you receive one, they're fully enforced. You have the right to appeal it to the Ontario Land Tribunal if you disagree with the fact that you've committed a contravention. You have the right to request that the information in it is reviewed and reviewed by, if it was issued by the deputy registrar, it can be reviewed by the registrar. If it was issued by an inspector, it's reviewed by the deputy registrar. So there is a process. We have issued compliance orders in the TIRES program that we are still working with the industry on, and that was last spring. These are legal instruments that take time. So I just want to make sure everyone understands, when you look at something like a compliance tool, like a compliance order, compared to communicating and explaining the why and explaining how and removing the barriers, that those first 3 steps in our progressive approach to compliance are much more effective and are much better utilized on producers and companies that maybe hit that yellow area of the matrix, that risk matrix that we were talking about earlier. When you start to hit the red, that's where the work and the effort becomes important. Next slide. Administrative penalties. As I said, this is, again, legal instruments here. We're not talking about issuing a parking ticket. The process is fairly involved, and again, as it should be, as producers would want it to be. Similar to a compliance order, if non-compliance is determined, we always want to talk through alternatives. We know this takes time with producers, but being a regulator that is heavy-handed and continually just issuing administrative penalties is, one, quite time-consuming, quite costly for the producers, since they actually pay our costs. It's a cost recovery basis, and we really want to be using these tools on high priority on those top right-hand quadrants of the risk matrix. So what is an administrative penalty, though? How is it determined? So the first part is that there's a base penalty amount, and those are set out in the administrative penalty regulation. The base penalty amount is calculated if you were to receive an administrative penalty notice of intent or an administrative penalty. It's going to explain to you how the base penalty is calculated, what RPRA has to take into consideration in determining that base penalty amount. The administrative penalty also includes something called economic benefit. What this is it's clawing back the benefit that the company enjoyed because of their non-compliance. So when we get specifically into free riders, we're going to talk a little bit about what that might look like and what that might be. It's absolute liability. What that means is there isn't a defense. You can't say, but I hired a pro. That's not sufficient. You either complied or you didn't comply. So this is very serious for your company. Again, RPRA, and we've spent years talking to the industry about this because it is new. RPRA is an EPR regulator. We are one of the first that have powers like this, and you need to start considering RPRA and your interactions with RPRA the same way you would if you were communicating with any other regulator like the CRA. These, unlike the compliance order, which can be issued by an inspector at RPRA, can only be issued by a deputy registrar or registrar. Next slide. I'm going to talk about the process. So we have 1 year from the moment that an inspector becomes aware of a contravention to issue an administrative penalty. So, as an example, if folks were required legally to comply with something on July 1st of 2023, have until July 1st of 2024. So we have time. We have time to ensure that we're following our best practices and our commitment to the industry, which is about communicating for compliance. It is about being the type of regulator who answers your questions and helps you comply. It is about being the regulator who believes in the principle that the vast majority of the industry wants to and will comply. So you have 1 year to do that with us, or it could be a contravention that sits so far up in that matrix that these are issued immediately. It depends on the situation. It depends on the case. It depends on the maturity of the program. So you can see how there's a lot of factors that could move things around. Issuing an administrative penalty against a producer who is 1 day late on reporting for their first reporting period ever versus considering an administrative penalty to a producer who continuously reports late, which has an impact on RPRA, the system, everything, who we're 5 years into the program. They're well aware of the deadline. They're definitely aware of our RPRA and our powers. You can see how there's different things that we need to consider. It's not just you committed an infraction, here's your parking ticket. So we take that base penalty amount we spoke about and we add an economic benefit. So for instance, the economic benefit in the case of failure to participate in a collection and management system or failure to establish one might be the cost of making a collection system and establishing one. The way that this works, and this is dictated in the regulation, and there's a lot of information on our website outlining all of these things that I'm telling you. So you absolutely can go read these things, and if you have more questions as you get into the details, to come back and speak to us. We issue first something called notice of intent. Notice of intent to issue an administrative penalty is sent to the producer or the regulated entity. There are others that can receive penalties. It's not just producers under EPR. And they have 21 days once they receive this notice of intent. 21 days to come to RPRA with information that might change the calculation of the economic benefit, or might change the calculation of the base penalty amount, or maybe to come to RPRA and say, I've complied, and I've complied to the past now. My goal is not to issue administrative penalties. We know we have to issue notices of intent to issue administrative penalties, but the hope here is that we don't have to collect. That instead what happens is that companies who receive these comply in the 21 days. It won't always be possible. We recognize that. So for instance, it's not always possible for us to compel compliance, including going backwards. Let's use an example of management requirements. If a producer has, let's say they have to recover 500 tons of something, 500 tons of rubber, or whatever it might be. And when it comes to the end of the year, they haven't done it, and no one's done that. There's no one out there that has excess tonnage that they can go to, whether that be a producer responsibility organization or service provider, to purchase the additional tonnage to say, I made it. If it just didn't happen, the producer didn't cause that 500 tons to be recovered, and it wasn't recovered, they can't comply in the past. So an administrative penalty may be issued, and there's nothing in that 21 days that they're able to go and do to correct that activity. And the reason this is important is because it's also about the level playing field. It's about making sure that producers who did comply, who did recover their 500 tons, right, aren't receiving some sort of lack of incentive for compliance because their competitors don't have to pay that amount. These have the right to be appealed. They get reviewed by management and they get reviewed by legal, just like in a compliance order. And non-payment, so you receive a notice of intent, you have 21 days. And then from the 21 days, you have, if the administrative penalty is issued, you have 30 days to pay. Non-payment is actually enforced by the courts. So this is serious, again. This has serious repercussions on your company. I want to talk a little bit, though, about when and where producers and the public see us taking these activities. Because a lot of what I've talked about so far, with the exception of a compliance order, when we issue a compliance order, we are bound to publish those on our website. You're not seeing us conduct necessarily all of the steps through this progressive compliance approach. It's not necessarily something we always make public. We do in some cases when we believe that making it public actually will drive compliance outcomes. But ultimately, you may not see it, and nor would you want us to share your name with your competitors and things like that. This is between you and your regulator. So when we issue notices of intent, that's not public. No one knows who receives notice of intent to receive an administrative penalty. No one knows if they don't issue, if the deputy registrar doesn't actually issue the penalty. So the 21 days, there could be something presented during that time frame that the deputy registrar says, I'm not going to issue the penalty. They have that ability. You as public will only know when we actually issue the administrative penalty itself. So you won't see any of that in between. And the reason that that's important is to protect these companies, right, who want to comply potentially and who are going to work with us and actually comply. So it is very important, but after the 21 days, we will post it. However, given the fact that that information isn't public, we have posted today on our website, and we will be sending out an email notification to all companies, all producers. We have issued notices of intent to issue administrative penalties for contraventions for being free riders under the Blue Box regulation and then under the tires regulation. So we have made that public. We have not made the names of the companies public, but we have made the fact that we have done this step public information because we think it's important that producers understand that we are doing these things. They just don't always see them. Next slide. So let's talk a little bit about Blue Box obligations. So next slide. So as I said, we've issued notice of intent to issue administrative penalties for Blue Box, very specifically the first three. So registering and reporting, collection system, and promotion and education system. These are the base obligations of an individual producer under the Blue Box regulation. Very important, obviously, is also meeting the management requirements. You need to make sure the first three bullets are accomplished in order to meet the management requirements. And the management requirements aren't coming to RPRA. Well, producers had legal obligations to have management requirements met last year for 6 months. They have them this year and they have them in 2025. Those reports, we won't know who's actually achieved their management requirements until the reporting period, which is later this spring. So pros or producers will come to us and tell us if they met the management requirements. So right now, what we do know and what we have evidence of is producers who have failed to do some of these three things under Blue Box, and we have issued notices of intent against them. Next slide. Let's talk a little bit about free riders, just so folks can understand some of the things that we're doing. So what is a free rider? Because I think some folks have different views of it. So it's important for RPRA to tell you what we consider a free rider. When we say we're putting our efforts on high priority free riders, what does that mean? So first, it's those who have not registered or reported to RPRA, or they've done so incorrectly. So what that means is you may be registered and reported, but you haven't done the correct supply data, or you haven't done either by omission, right, by an error, or by on purpose, you haven't given the correct information to RPRA. So that's the first type of free rider. The second that we consider is someone who has not established a collection and management system if they're required to do so. Not all producers who have to register and report are actually required to set up a collection and management system. As part of this is important in Blue Box. The way that obligation works is that you need to ensure, as of July 1st, 2023, that a collection system going to Ontario residents' household is actually established and being operated. It is very much so not feasible for a producer to establish that on their own. It's certainly something that's available in the regulation, but we're talking about millions of households that an individual producer would then have to serve. So there are pros who can provide this service for you and help you comply. So if you have failed to join a pro, if you have failed to demonstrate to us that you have established services to millions of Ontario residences, you have failed to establish a collection management system. And that is a contravention, and it was a requirement on July 1st. The other option, the other concept of a free rider is you've established one, but you're not actually operating it. So in Blue Box construct, you can imagine what that would look like. Yes, you have the infrastructure there, the ability to do it, but Ontario residents aren't actually getting the service. So this is what we consider a free rider, and that's really important so that when I say free riders are a priority, this is what we're talking about. When I say my team is focused on free riders, they're reviewing the data. They're doing the work to make sure that these producers are in compliance with these three things. It's not just those who haven't registered with RPRA. There's more to a free rider than that. Next slide. So what are we doing about free riders? So I've said this, free riders are a compliance priority for RPRA. So that's the type of contraventions that we just covered are the top right-hand matrix. However, we spoke earlier, and we can do this exercise, tonnage is important. Impact on the outcomes is important. So you could be committing a contravention that puts you in the top right-hand matrix, but because of your impact on the system as a result of that contravention, you actually move down into the yellow or green. So we do that because we want to go biggest bang for buck. That's the basic principle here about being effective and efficient. We want to go towards the producers that are in fact having that high impact on the system. So we're looking at, have they registered? Let's talk about that for a minute. You can't take Stewardship Ontario's list and compare it to RPRA's. The definitions of producers have changed quite a bit. We have many companies registered with us now that were never registered with Stewardship Ontario as a result. We have, because we are a regulator and Stewardship Ontario was not, we have rules and laws around who registers. So maybe under Stewardship Ontario, you had 6 departments in your company that were registered because that's the way you wanted to set it up. That can't happen with RPRA. So you might see 6 producer companies turn to 1 on RPRA's list. You might see also, because of the changes in definition of what is a producer, maybe there was 30 retail outlets in Ontario who were obligated because they were importing something from outside of Ontario, as in they were importing something from a brand owner who maybe was in BC, didn't have any residence in Ontario. Those 30 companies are no longer registered or reporting to RPRA anymore because the one company in BC is. And we have hundreds of producers who were not registered with SO as a result of this. So that's the first thing that we did was taking a look at Stewardship Ontario's list, and we're continuing to do analytics on that list. We're continuing to work to ensure that producers are reporting correctly. There were changes to the definitions of what is obligated. So there's a lot of work and effort going into that. And we're continuing to ensure that establishing a collection and management system has occurred along with the associated P&E promotion and education system. So and we'll do this exercise actually in a moment. We'll continue going through with what we're doing. We're focusing again on the high priority. So those are the contraventions that are a high priority, but then we also layer in tonnage, and we have that information, right? We're moving people to enforcement. As I said, we have issued notices of intent to issue administrative penalties. We are collaborating with industry, so with other retailers. For instance, we might work with them to ensure their suppliers are registered with RPRA. We're speaking regularly to industry associations. We're also using investigative techniques. So who is a producer who never registered with Stewardship Ontario? either because they didn't know they had this obligation or because they are now newly obligated with the changes to the regulation. Next slide. So again, applying the compliance matrix, right? Where do you want RPRA focused? So areas where you might see us focused, as I said, because registration is a free rider, you might see that we're focusing on high tonnage producers, right? Those that will have a high impact on the system, that were never registered with Stewardship Ontario for, like I said, many reasons. It could be because they didn't know. It could be because they weren't complying with Stewardship Ontario. It could be that they are now legally required to register. And there are many in that bucket, right, that we're communicating with, we're having conversations with. Some of these companies are shocked to find out their obligations, and we're working with them. But we have the time to bring them into compliance using the values and principles we believe, which I've covered a few times now. And we will do that. We will work with these companies. Another focus, so what else might be in the high priority section here for the compliance matrix, is a company with a significant amount of tonnage who has committed one of the contraventions of being a free rider that I've covered. That is a focus as well. Someone with a low amount of tonnage might be edging to the bottom left-hand corner of the box right now. Doesn't mean we won't communicate with them, work with them, focus on them, but using our resources to go after producers like that is cost prohibitive. Spending $1,000 to get 500 doesn't make sense. And that is sometimes, it's not the math, but those are the decisions we have to make when we're looking at free riders. Will we have 100% compliance? There is no such thing. And compliance isn't the outcome here. The outcome we're looking for is the ministry's policy objectives. What are these regulations supposed to achieve? Will we continue to treat free riders as a high priority? Will those contraventions always exist in the top right? Yes, absolutely. Level playing field is of utmost importance to us, but we must apply our resources in an effective and efficient manner, consistent with our values. Next slide. Believe we're on to Q&A. So I'll pause there and hand it over to the rest of the team.
Thanks, Mary. So we have a question. It was asking at the beginning, and you did review this, but I think it's worth reviewing it maybe a little bit more in depth. But just wondering what RPRA's compliance risk matrix is based on.
Sorry, can you say that again? What it's based on?
What it's based on.
So the compliance risk matrix is based on the best practices of every Ontario regulator. We all utilize a risk-based approach with a progressive compliance approach, all of us. So whether you're dealing with Ministry of Labor, whether you're dealing with Ministry of Environment inspectors, we're all utilizing that same approach. It's part of being a modern regulator.
Thanks for clarifying. We have quite a few questions about this. So producers are wondering how they can know that their pro is operating a collection and management system and reporting on their behalf correctly.
You can call RPRA, speak to us, ask your pro for information, evidence that they're performing the deliverables of the contract that you've asked them to do. So you could ask them to do that component. I think it's important because this is an individual producer responsibility framework. The producers are engaged with their pros, engaged with RPRA. That's why RPRA is here, is to help you with that. If you have concerns about it, come to us and talk to us so that we can help you navigate it. Be proactive. Ask the right questions. In the WDTA world, the Waste Diversion Transition Act world, in the Waste Diversion Act world, the principle was very much so. Producers reported, they wrote a check, and they were done. This is different now. You need to be more engaged, and we're happy to help you with that. Happy to help explain to you how you can do that. But I think one of the first steps is speak to your pro. What is your pro? And I know in Blue Box the pros actively engage with their producers, and they send out this information proactively as well. So I know that these things are happening in terms of them communicating with their producer clients to say these are the things we've done and this is why you are compliant and what's occurred. So I know those conversations are happening, but if you're not getting that information, if you're confused by it, you can call our RPRA. We can help walk you through it. You can call your pro and they can help walk you through it.
Thanks. Sorry, just going through the chat. There's quite a few questions about free riders, so we can answer those again. Mainly about what information do we share about free riders? Do we share any stats about free riders? How many are we currently pursuing that are in high, medium, or low risk?
We do actually. It's on our website. So we do share quite a bit of information. Maybe Marisa can take a look at that for us and come back and answer a little bit more question about some of the information that we have on our website about how many active cases we have and what's going on. If you want to move on to the next question, then Marisa can maybe come back and do a little summary for the group.
Yeah, someone's just wanting clarification about if administrative penalties go public.
Clarification if they go public? Like
Yeah,
what the
if they're
process looks like?
posted, yeah.
Yeah, sure. So the notices of intent are not public. So as I said, we have begun issuing those. And so we won't be releasing any information on the notices of intent. In 21 days' time, should an administrative penalty actually be issued, that information, which includes the amount of the penalty, the contravention, the company name, will be posted on our website. And then, as I said, 30 days, court enforced.
Thanks. Sorry, still going through the questions. A lot of them are very similar about free riders, so. So there, I know we're focusing on free riders, but we did touch upon this in the presentation, and there are quite a few questions about collection and management. So what we could just, a question is, what do producers who have management requirements need to do to meet those requirements?
Absolutely. So what you need to do, if you have management requirements, you need to ensure a collection network is established and operated. And again, that's millions of households. It's being done in 3 tranches across Ontario, with the whole transition being completed January 1st of 2026. Producers are able to do that and comply on their own without a pro. They could speak to the system access administrator. There's more information on this on Circular Materials' website and RISE's website, and I believe H2 compliance. So if you wanted to understand what's happening behind the curtains with the pros, there are things that producers could do to try to comply on their own. The reality is the vast majority of companies will sign up with one of those pros in order to ensure that the collection system, that there's a system that's been established. But you can certainly explore your other options. You can call our RPRA inspector and we can walk you through what those look like. To date, all producers are signing up with pros. So that would be the key thing that would help you establish a collection system. Then you have to ensure that system's operated so that those blue boxes are being picked up. And then you have to ensure if you had to have 500 tons of plastic, that 500 tons of plastic is in fact then recovered. Again, you could try to do this on your own, and we're happy to walk people through that process. But ultimately, the regulation envisioned producer responsibility organizations. It speaks about them. It creates obligations on them. All of the producers to date are signing up with producer responsibility organizations who establish, operate that collection system, and who then have fulfill the management requirements for the producers by recycling the material, by recovering the material that needs to be recovered. I hope that helps to understand how you do it. If you have management requirements and you do not have a pro, you are a free rider, unless you have been able to demonstrate to us that you're servicing millions of households. You are a free rider. You need to call RPRA immediately. If you're not sure what you need to do, we will walk you through it. But notices of intent are being issued. So if you're in that bucket, call RPRA immediately.
I just wanted to pipe in about your
Perfect,
question.
Marisa, thank you.
We actually didn't publish specific numbers on how many free riders we brought into compliance in our latest annual report. But I can say it's a high priority for our compliance team, both in terms of producers registering and reporting to us, and in terms of producers who are not fulfilling their collection system requirements, as Mary's spoken to a few times. We are using our resources in a targeted way, focusing on the high priority free riders, both registering and with their collection system obligations. And those compliance plans and campaigns have been fairly successful so far. So we'll hopefully have some numbers published in our 2023 annual report.
We do have some information on our website around free riders. So for instance, you can we'll maybe make sure this link is included around our public reporting. It shows how many free riders by program we have. And so there is that information, so you can see what we're actively working on. But I think Marisa's right. Last year we may not have included the number that we brought in.
Yeah, so we have published the number of potential free riders. So these are people or producers that we're aware of, that we're currently looking into, but numbers on actually brought into compliance have not been published.
Thank you. I think this question is worth just clarifying. So if a pro is failing to meet their responsibilities for a producer, is RPRA going to inform producers or announce this information?
Absolutely. These are producer responsibility. These are the individual producers' obligations. They do need to know this. We work with the pro, obviously, to depends on the contravention. Is this something that the pro can address and work with them on? But we have and do communicate with the producers one-on-one when that's occurring. They need to know that information. Same way, if your auditor isn't doing their job with CRA is going to let you know. Michelle, if it's helpful, I see a few questions that I could help with that are coming in.
Feel free.
So how many pros are authorized by RPRA? So there are 3 pros registered with RPRA, I think 3 for Blue Box. They're not authorized by RPRA. And this is going to get into a few questions I'm seeing here around pro fees. Are they regulated by RPRA? How do we know if our pro's charging us the right amount? Anyone can register with us as a pro. There is no approval process. There is no authorization. This is a private company coming forward and saying, I have compliance services to offer companies in Ontario. So when you're speaking to a potential pro, you need to know that, just like any other service you acquire for your business. This is a market-based conversation, and you're procuring compliance services from a private company. So you want to have that conversation with them. How are you doing this? You know, how are your costs determined? What am I paying for? All of those things are between you and the pro, and RPRA is not involved, nor do we oversee that process whatsoever. So it's really important that folks understand that.
There's also a lot of questions regarding fees for pros, Mary.
Yeah, so the fees are set, the costs of a pro are set by a pro, much like any other private company. So what I have no visibility in what their costs are. I have no visibility into how they determine their costs. I don't regulate that. No one at RPRA does. It's a conversation between you and the pro. Are there
Lots
more
of
questions?
I'll just say there's questions about fees and where to find more information, and we'll respond in the chat with links to our website, so you have the direct link.
So fees, they're going to be questions about not RPRA fees, but the pro fees, likely. So there won't be information on that on our website. That's if it's RPRA fees, yes, we'll put the link in. I just want to make sure everyone understands there's RPRA fees and then there's your pro fees. RPRA fees are less than 1% of system costs of actually doing this. So if you have questions about pro fees or what they are, you need to speak to the pro.
Another question about the compliance matrix. So we talked about how free riders are high priority. Are there other examples of high priority, medium and low priority that we want to share?
Absolutely. So free riders are probably our biggest one. So what that is again, failure to establish a collection system, failure to operate a collection system, failure to hit management requirements, failure to register and to report. Those are some of our high contraventions, but there are a lot of things in this regulation about keeping records. There's failure to respond to an inspector's inquiry. Depending on what that inquiry is, it could fall somewhere on that risk matrix. So if an inspector is asking you a question and is saying you have 5 days to comply with providing me the information or a response, depending on what that question is and the system impact it could have, it could be a high priority for RPRA.
Thanks, Mary. I think so. There's a lot of specific questions here, and again, we'll reply to the ones that we can, providing links to our website. But I think for now,
I see a few more like that I'm happy to address. So yeah, I see one here asking question about how this works in terms of compliant producers footing the bill essentially for non-compliant producers. So the point of the system here is that we're bringing those producers into compliance using those tools that we utilized. The producer, when they receive a notice of intent to issue an administrative penalty, that penalty will be more than the cost of them complying. We've worked with the pros to do that. So the decision is up to the producer ultimately, but it will be more cost effective for them to comply, to go to the pro and comply, therefore eliminating them as a free rider, and therefore eliminating the issue of the producers who have signed up with a pro and are complying with the regulation from having that issue. As I said, my goal is not to issue these administrative penalties. I want folks to comply. That is my goal with this. So that's how that works. I see a question about, this is absolutely a focus to Blue Box, but yes, it's the exact same process for tires, batteries, ITTAV. Question, are we able to change a pro in a given year? Absolutely. There's nothing that from our end that prohibits that, but you may want to review your contract with your pro to see what it says about terms and conditions and termination. So that's between you and the pro, these private businesses that RPRA does not approve. We do not oversee their finances. We do not approve their costs. So when you're signing these contracts with them, this is a legal agreement that you're entering into, much like anyone else. If RPRA is like CRA, why do we need to pay fees into RPRA? So that's because we're like CRA, but there's other regulators that are like RPRA. So for instance, OMVIC, they regulate motor vehicles, or the retirement home regulator. They also, just like RPRA, charge the fees, the cost of their organization to those who they regulate. So there's different constructs that can be created. If you're delegated, if you're administrative authority, so if you're a regulator who is outside government compared to a regulator who's inside government, so CRA or Ministry of Labor, the way your cost structure and your funding is set up is different. So OMVIC charges dealerships in Ontario fees to cover their regulatory costs. Same with retirement homes, right? Retirement homes have to pay that. Real estate agents, all of the regulators that are administrative authorities have funding set up that way. And then there's a different model for some of the other regulators in terms of how the funding works. Hope that helps clarify that. Does RPRA have a list of approved pros? Covered it. It's up there, but they're not approved. Really important. You have to do your due diligence as a producer, just like you would when you procure any service. Why do we pay RPRA fees and pro fees separately? So that's really, you could consolidate them, yes, and they were consolidated more under the Waste Diversion Act, but that's not the way that RPRA is set up. RPRA is set up as an administrative authority, like other administrative authorities. You pay directly to RPRA, and then any costs that you incur for compliance is paid separately. In other regulations, not in Blue Box, but in other regulations, you have producers who don't have pros. So they're only paying RPRA fee and they actually comply without a pro. So it's not, you can't just pay your pro. Not all producers actually require pros. I think we have 3 minutes left. I don't know, Michelle, if you or Marisa saw anything else come in that I could quickly cover.
Maybe the question about when's 2026, just clarification that that producers will be paying for just a pro for the new Blue Box regulation, and their Blue Box contributions to Stewardship Ontario will no longer exist. So maybe just clarification on that.
I don't really quite understand. So is it saying, like, when do you stop paying Stewardship Ontario?
Yeah.
Is that the question?
And what happens,
You need
I
to
guess,
contact,
as of 2026?
No, you need to contact Stewardship Ontario to find out when your obligations to them end. So speak to Stewardship Ontario. They're the ones that can tell you what you need to do to fulfill and close out your obligations with them.
Okay, and then just one final question before we just ask for some feedback. Someone just wants, if we can just reiterate what our big announcement was during this webinar.
That we have posted on our website just this morning, and we're about to send it to all producers, that we have begun issuing notices of intent to issue administrative penalties against free riders in tires and Blue Box. And they have begun, they've been issued. Producers have received these. They have 21 days.
Thanks, Mary.
All right.
Okay. So 1 minute left, but we are going to launch a poll. We normally ask for feedback, just so it'll help us improve future webinars. So we really appreciate your participation in the poll. Just a few questions. So we'll launch that now. And just to reiterate, this presentation deck will be posted on our website shortly, either today or tomorrow. So you can review those slides. There's also a lot of other helpful resources available on our website that review other requirements under the regulation. So make sure to keep an eye out for that.
I'm also seeing just a lot of general questions about things that I'd love to chat more about, but we're out of time. Please call our compliance team. They can answer these questions too. They don't need to just be me. We do have a team of inspectors who can absolutely answer some of these questions for you.
Thanks, Mary. So we just ended the poll again. Thank you to everyone who participated, and thanks for joining us this morning. We hope that this was helpful, and we wish you a great rest of your day.